Well, I got inspired too. I've got to tell you, Mr. Parkinson, I'm really curious. What is the worst case scenario offense that you all would investigate?
Worst case offense, manipulating the energy markets.
Okay. And I was a little surprised in regard to the Brady information, and you said, well, what would be helpful? Inculpatory information could be helpful. Yeah, it is helpful. If you're trying to defend somebody who is being accused of doing something improper, having all the information is helpful. And you said, well, this will be just like an open file policy. Well, I always found in my years of lawyering that the really good prosecutors, and I don't know how y'all did it wherever you were, but the really good prosecutors, unless it was a serial murderer, child sex offender, something really heinous, they gave you the open file because it helped you reach a settlement. And so I don't understand the resistance. I'm having a real hard time sitting here listening to you talk about how there's some kind of, this is our problem. Giving people information so that you can reach a settlement is a problem. That's not a problem. That's the way you want to get a lot of these cases resolved. It would make you all more efficient. You could get onto bigger problems. It's the people that you're not talking to. And then you seem to have a problem with giving a witness their own statement. How in the world is that not just regular course of order? I mean, maybe it's just a southern thing or a small town thing, but I think if I make a statement to you, I ought to have a copy of my statement. Now, if you want a court order that says I can't talk to anybody else, that's fine, but I'm going to remember most of my statement to the ability that if I'm going to go out and try to collaborate or get our stories straight, I'm going to do that without a written transcript of my statement. But if I want to be able to show my lawyer what's going on or maybe get advice from a second lawyer, that seems to me to be reasonable. Can you answer any of these questions for me? And I got more.
Yeah, sure. I'd love to, Congressman. Let me start with the first one about this is not a hide the ball kind of process.
Because that's what you made it sound like.
If I made it sound that way, then I misspoke or is misinterpreted. We're talking about a pretty narrow issue about Brady, which is what the amendment does. We have a process at FERC, in FERC enforcement, where we lay out in extraordinary detail for the subjects of our investigations everything we've concluded, everything both factually and legally. We lay it out often in preliminary findings letters that go on for dozens and dozens of pages. Unlike any other federal agency that I'm aware of. We have regular communications with counsel throughout the investigation. And near the end stages of the investigation, we lay out our preliminary findings. They have an opportunity to submit with no limitation on length, whatever they want to submit. There's two other additional opportunities to do that.
But I guess my problem is your testimony earlier was you were opposed to some of the language that does just what you're saying you do. Why would you be opposed to something? If you agree with me that it's the right thing to do and the fair thing to do, why would you be opposed to it?
There's a significant difference between laying out everything we've concluded and laying out during the course of an investigation, which is what this is talking about. This is not the adjudication phase. This is not the phase where we've brought charges and there's a process in place.
Let me go there because I could probably go on for an hour. I'm troubled by so many things. So let me get this straight. You all have a process. I mean, I think the bill ought to be expanded, Mr. Chairman. You all have a process by which the commissioners are involved in the investigation because you then establish an attorney-client relationship with the commissioners, and then those same commissioners are judging the case. Now, let me give you an analogy that I think is fairly close. You got a building official who's investigating somebody who may not have followed the building code in building a building. And they go talk to the judge in advance and say, how do you think we ought to investigate? How do you think we ought to lay out our case on this? And then you expect that the defendant or the person who is accused, whatever terminology you use, thinks they're getting a fair hearing when they walk in front of the judge who has an attorney-client relationship with the person who is prosecuting them. How does that work?
Well,
how's that fair? How's that due process? And I'm running out of time, but you said a couple times that, some of these things could be burdensome. Yeah, due process is burdensome. Liberty is hard to hold on to, and having the government not take your property, your money without a fair hearing is burdensome, but it is the American way. And so next time you start talking about how these requirements might be burdensome, you might want to think about, in the real world, people hearing that think that you've got some kind of cloak and dagger operation going on that is not a due process or fair system. And I'm out of time, so I yield back.
Gentlemen, yield to me a few seconds.
Sure.
I want to yield. Do you want to respond to that, Mr.?